Hello, my people. For those of you who are asking me about the whereabouts of Nnamdi, whether Nnamdi has been released, what is happening to his case, whether we have seen him and what have you. For a couple of days now, I have received several calls within and outside the shore of this country, Nigeria, and people are trying to say that they saw a trending news that Nnamdi has been released, that we had that we went to court of appeal, why we went to court of appeal, and what have you. Have been explaining. But I feel that it is nice for me to make this video so that everybody will understand the position of things. As we speak now, I, Maxwell Opera, a member of the legal team of Nnamdi, have not set my eye on Nnamdi nor hear from him since 24th day of September 2024, when we went to court last. I don't know why the DSS decided to behave in this manner, simply because Nnamdi told the judge that I have lost confidence in you. I don't think that I will get justice from their court. You have been biased. He marshaled out his reasons, and the judge said, okay, I have heard. I'm going to send the file back to CJ for the assignment for another judge to hear it, which is normal. It is admissible in practice of law. Now, since that day up to now, the DSS practically refused us access to Nnamdi. I don't know whether Nnamdi is alive. I don't know whether he's still in DSS custody in Abuja. I don't know his whereabouts. As his lawyer, we have been going there severally because there is a valid and subsisting court order directing DSS to allow Nnamdi's lawyer, his family members, friends and well-wishers to be visiting him twice every week, Mondays and Thursdays. That order, DSS in their usual way flouted that order. And this is one of the things that made us to file from 48. And we also applied to court, asking court, look at our challenges. We, under section 36 of the Constitution, somebody that is facing criminal trial has a right of adequate time and facility within which to prepare for his defense. They refuse us access. We don't have an adequate time and facility to prepare Nnamdi for his defense. And we challenge. That's one of the things that brought us to court. So for those of you who are asking whether Nnamdi has been released, he has not been released. Whether I have seen him, I have not seen him. Whether I know his whereabouts, I don't know his whereabouts. If you should ask me, yes, court said that he should be detained in DSS. I don't know whether he's still there. That I will tell you, because they refused me access to see him. That one is on that. On why we went to court, of appeal yesterday. We went to court of appeal because we have 3 appeals which we filed from High Court to Court of Appeal. What are the issues? The first one is court and the Supreme Court. Remember that we got judgment in Court of Appeal. Where Court of Appeal, the 3-man panel, said that Nnamdi discharged Nnamdi from all the whole charges. 2, that the way a man of Nnamdi is brought from Kenya to Nigeria, they condemn it. They condemn all the actions of the government and order that Nnamdi should be released immediately. They refuse to comply with that order. I'm talking about the DSS and the federal government. They refuse to comply with that order until 8 days. When we wanted to take the director of DSS on contempt proceedings, they quickly filed notice of appeal and what they call notice of appeal against that judgment to Supreme Court and filed motion for stay in a criminal matter. Now we went to Supreme Court. Supreme Court, after hearing our matter, agreed that Nnamdi never done bail. Agreed that the court ought not have revoked his bail. Agreed that the way a man Nnamdi is brought from Kenya to Nigeria here is unlawful. They also condemned the actions of the federal government of invading Nnamdi south with Operation Python Dance, the military, the army. the soldiers, they condemned this act and said that we should go back to the Federal High Court and Nnamdi Kanu should go and face the trial. We don't have a problem about that. We agreed. Now we brought this judgment to the court. So you can now see what the Apex Court said. Not Court of Appeal this time, but Supreme Court. Please, can you restate the bail of Nnamdi Kanu? They said that you ought not have revoked his bail. He refused. She refused. The judge refused. We appeal against that. Now the law under which they charge Nnamdi Kanu, that Terrorism Prevention Act, has been repealed. It's no longer in existence. We said since the law is no longer in existence, what are you still charging him? Court, please, based on that, discharge him. The judge refused. We appeal against that. Now we apply to have arbitrament facility with Nnamdi Kanu, asking court to order that they should allow us to have free access to prepare him. That order was not made. We appeal against it. These are the three issues that took us to Court of Appeal. Then yesterday, the matter was heard. So on the issue of the displacement of his bail, they said that the record of proceedings of that particular day, the judge revoked his bail, was not there. And we told the court that we applied. Look at what they gave us. Even when they demanded it, they said this is what they will give us. That's the order. The panel said that we should go back to that place and brought that record of that particular record of the proceedings of that day. So, and adjourned the matter 13th of January. The question is that why 13th of January? Somebody that is under incarceration. So, but that one is the talk of another. They have applied. We are following it up. The other two appeals was also hard, and they said that they have adjourned for judgment, and they will communicate to us on the date of the judgment. Now, on Monday, I think that was on the 14th. On the 14th Monday, we went to 14th of October. That's the previous Monday. Monday this week. We went to DSSS, applied again for us to see Nnamdi Kanu, for us to have a discussion with him, if he's still with them, if he's still alive, for us to have a discussion with him against the matter that came up yesterday, 17th of October. We went to that place. Brethren, they refused us. First of all, when we came, they said that all the lawyers from Nnamdi Kanu, we should park outside the express, then and walk in their premises with left, which we did. Whereas other lawyers that came to see their clients, we are also allowed inside to join their car. They said that we should not go inside with our phone, that we should drop our phones in the car, which we did. But when we were in the reception, we saw other lawyers, our colleagues who came to see their clients also. They were with their phones in the reception, waited. They were busy calling lawyers who are seeing their clients until remaining us. Around 5,000 about they come and tell us that we're not going to see Nnamdi Kanu. Why? That the order is from above. Against court order, that was why we suspected something must have happened. So that is the position we find ourselves. And I am calling the people of Nigeria. This persecution of Nnamdi Kanu is too much, especially the people from Southeast. This persecution is too much, and this is high time everybody should join hands. The lawyers, the civil society group, the political leaders, the religious leaders, and what have you, to protest against this. Nnamdi Kanu is a freedom fighter. He's not a terrorist. Everybody knows. You said that he made a comment. A comment of what? People have made comments more than the one Nnamdi Kanu, you feel that Nnamdi Kanu has made in this country, including the wife of the president. During the time when they were campaigning for election of 2023, he said that Igbo should leave. Oba of Lagos said that Igbo should go and die in Lagoon. People refused Igbos to come and vote in Lagos. Open threatening, nothing happened. Nobody tried them for terrorism. It's only Nnamdi Kanu. The people that we see that have committed the act of terrorism in this country, they were allowed to go. It's only Nnamdi Kanu. This persecution of Nnamdi Kanu is getting out of hand.
On the lower court. So I was actually surprised that a high court have refused to obey or abide by the determination of a Supreme Court judgment.
And then take the only part that is against him and then refuse to apply the part that is in favor of him.
This cherry picking of what was contained in the Supreme Court judgment is what I'm against.
Yes, that's correct.
It should be implemented holistically.
Yes.
I'm not against taking any trial.
Judgment.
After all, I'm innocent, so they have nothing against me. But there cannot be any trial when key sections of the Constitution and a key Supreme Court judgment has been violated by a court of law.
Are you concerned that this patient for the case to go back and come back to the court?
This is my 4th year in solitary confinement in detention. The 5th year will not kill me.
Sorry, what if the case is also reassigned back to her? Will you still be comfortable?
It's not going on.
No, it won't happen.
It won't happen. It doesn't happen.
It doesn't happen that way. It doesn't happen that way at all.
Thank you very much.
These are the things that the public must understand. Most of you journalists, the legal correspondents, you don't take time to actually study some of these rulings and judgments. Go and study. In fact, I'll give you...
Bring that envelope. Bring the envelope.
The brown envelope. Look at it here. Look at it here. Look at it.
I'll give it to her because I think she's a bit more...
Give her the Supreme Court judgment.
Can you hold this for me?
She can...
I want to let the whole world understand something. Very, very clear. In all this is judgment of the Supreme Court. It made it very clear that even that the impartiality of the judge is questionable. And is here. Where is it? Please do bear with me. It says it here.
I like
what is it. Page? What is that again? Where it says
page 18.
all these things are online. Is it not page 18? All these things are online. So I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult, just minor research. You will understand the virtuousness, the emptiness of all the charges against me.
Okay.
They kept switching the charges. They said I committed this crime in England, isn't it?
Yes.
I made a broadcast in England.
Yes.
And in 9 charges leveled against me, this place where I committed this crime was London in the United Kingdom.
Yes.
When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it?
Based on that, they removed London.
Based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196,
174 of the Terrorism Prevention Act 2022.
in violation of their own laws. Violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible.
To the trial.
Because